Dear participants, on behalf of Validity Foundation, please accept my warmest welcome to the 5th webinar in our webinar series on tackling torture against people with disabilities in the context of the COVID-19 pandemic. It has become a tradition in this webinar series to greet you all with good morning, good afternoon, as well as good evening, as we are welcome from all over the world, from India, Kenya, Mexico, Argentina, all here. The webinar's title is Legal Strategies to Pursue Emergency Deinstitutionalization During the Pandemic. As the title suggests, we will be talking about discharging people with disabilities from institutions as an emergency solution during the current pandemic. As we all know, it has been extensively covered in our previous webinars. People in institutions have been disproportionately affected because of how fast the virus spreads in institutions. They represent up to 72% actually of those who died because of the virus. In this webinar, we will discuss how to prevent this by pursuing emergency deinstitutionalization and how we as lawyers can help. We will discuss what it is, emergency deinstitutionalization, how to implement it in practice, how to frame it as a legal obligation, as well as tips how to effectively litigate it. We have 3 excellent speakers whom it's great pleasure for me to welcome at this webinar as well. Dr. George Nikolitis, who is an expert in psychiatry and serves as the national representative of Greece, and also as the representative to Council of Europe Lanzarote Committee. Dr. Facundo Chávez, who is the Human Rights and Disability Advisor at the Office of the United Nations High Commissioner for Human Rights. He is an expert in human rights and disability. And finally, Dr. Janos Fiala, who is a lecturer in international disability law at the Centre for Disability Law and Policy at the University of Galway in Ireland, and who's an excellent human rights attorney. But before I get to introducing our speakers in detail and to asking them to present their topics, I would like to set out some housekeeping rules just to make sure that the webinar runs smoothly. I would like to remind you all that it is recorded, and for this reason, and to make sure, of course, that other speakers are not interrupted, please make sure your microphones are muted when you're not speaking. The webinar will run for 90 minutes, and after 3 presentations of the speakers, we will have time for discussion. We are warmly welcoming questions part of the webinar. Please type your questions in the chat box. We are not using and type it. Please use the raise your hand function. If we have enough time, we will enable you to speak to ask your question. I'm glad to welcome also sign language interpreters at this webinar. I hope they are visible to all of you. And to make sure that this is the case throughout the webinar, I will ask all speakers to have their cameras off when not speaking. This is to ensure the visibility of sign language interpreters. And lastly, if you have any technical problems in relation to the webinar, please do let us know in the chat box. Our excellent administrative assistant, Jafia, will try to help you with that. Now, with these practical notes out of our way, it is my great pleasure to invite our excellent speakers. The first speaker is Dr. George Nikolitis. Apart from being an expert in psychiatry and epidemiology, as I've already mentioned, George has also a master's in the philosophy of mental disorder and psychoanalytic studies. In his work, he focuses on violence, child abuse and neglect, and public health and epidemiology. Worked as a research director at the Department of Mental Health and Social. He was the scientific coordinator of the daycare center, the House of the Child, and later worked as an advocacy and networking consultant for Lumos Foundation. He has close experience from within institutions and also with emergency response to violence and neglect happening there. George will explain to us in his presentation why and under what circumstances can emergency deinstitutionalization be the needed solution in the correct situation. George, the floor is yours.
Thank you very much, Sarka. Good morning, good afternoon, and good evening. And on my behalf, I'm very glad to be here at this great opportunity to discuss the issue of the necessity for urgent institutionalization initiatives in the context of the current COVID-19 pandemic. First of all, let me make some preliminary remarks. The first one would be that when we are using the term of institutions or institutional care, or sometimes residential care, we are referring to a multiple variety of different realities, different situations, including not only traditional institutions like residential care for children in care, or other types of facilities in which the elderly reside, or facilities of residential care for persons with disabilities, places in which there are long-term placement of chronically ill persons, other types of institutions which traditionally used to be mental health hospitals, but practically they were and still are to some extent places of long-term placement of persons with mental health issues. But we also refer to situations such as prisons, camps for immigrants or refugees, or other types of usually marginalized groups of population, which already have some or other reasons of vulnerability. So we are talking about any kind of facility in which you have concentration of people, usually people who already have one or multiple vulnerabilities already. And now I'm saying that because given the context of the current COVID-19 pandemic, the world came to realize that it's of paramount importance that we minimize, reduce, eliminate, if possible, all such facilities in which we congregate, we concentrate lots of people, especially the vulnerable ones. And that applies to all kinds of setting like that. Of course, with the most vulnerable being the elderly and people with underlying medical conditions like chronic illnesses and other such causes that made them more susceptible to have severe disease if they get infected with the coronavirus that is causing the current pandemic. I will just show you a few slides just to get an idea of how much of the danger that the whole world is facing is actually attributable to residential and institutional care, with some examples. Sometimes in the mass media this has been reported, but I think that this has not been as highlighted as it should, because evidence is compelling that coronavirus pandemic, of course, represents a threat, but the threat is by many times multiplied if someone is placed in institutional or residential care. So let me just show you a few examples on that. Just wait a second until the screen is shared. And I think that by now it is, yes, it is shared. So you can see in this table, I'm not sure whether you can see the font size is a little big, and for instance, for me, I'm getting old for so small font size. But you can see that in many countries, the number of care home resident deaths as a percentage of the totality of COVID-19 deaths in the country ranges from 75%, 36%, 61%, 80%, 35%, 46%. This is an enormous proportion of the fatalities that we have faced as a global community. And we should have been able to learn from this, that there's something that places people to an additional risk, and that is someone living in residential care. You can see here that in many countries, the percentage of people living in residential and institutional care in care homes that actually died because of the COVID-19, in some cases like Spain, exceeds 6% of the population. That's an enormous percentage. You can see also in this slide that if you make a sort of graph correlating the deaths per care home population to the deaths per non-care home population, you get an almost even equation indicating that the more people, the more someone is placed in, if someone is placed in a care home facility, the possibilities are multiplied for someone to pass away from COVID-19. And you can see a map which is quite old, it's some months ago, which depicts the percentage of deaths occurring in nursing homes and assisted living facilities in the United States of America. And you can see we have get used to that kind of maps due to the current elections in the US, but this is another more dark, more sad map. You can see here that there are states in which almost 3 out of 4 deaths attributed to COVID-19 actually happened in people residing in institutional and residential care. And the same here for Belgium, the leading, in quotation, country insofar in mortality from COVID-19 in the world. It still has the higher number of deaths from COVID-19 compared to the population. You can see here that, okay, even in this country in which situation is really bad, your chances of dying out of COVID-19 are at some level, which you can see in the lower graphs, curves in the slide. But if you are placed in a residential placement in a residential or institutional care home, then your probability of dying out of COVID-19 is so high. Now I will stop here. I could show a lot of graphs and other such numbers, but I think that there's growing evidence that is beyond any doubt that residential placement is a very dangerous thing in the current context of the pandemic. Now, on top of that, people placed in such facilities, all types of such facilities, also faced a number of additional hardship during the pandemic era. We know that in many countries, a lot of governments or even private providers imposed extreme quarantine measures in order to detain the population that was congregated in institutional facilities. For instance, we have reports from prisons that all visitation was cancelled for a considerable amount of time. Or I can tell you from my own country, Greece, and that's a real shame for me to be in a position to report that camps of refugees and immigrants faced an extended quarantine, which actually made all of them hostages to this situation, just because in a camp in which 3,000 people reside, 1 or 2 cases of COVID-19 were detected. Now, that also represents a discriminatory behavior on behalf of the state, because no such decision was taken to a block of flats or to a neighborhood. That is the equivalent thing. People placed in those facilities were treated like with an additional burden and with more severe restrictions compared to the entire population. We also know from reports from many countries like Spain, Belgium, Sweden, and other countries, UK, Canada, that in some occasions, especially in residential care for elderly or for chronically ill, the measures imposed to keep the virus outside were so harsh that people were really depressed because they had not seen anyone from the outside world for months. Now, we also know that some of these people, whenever one case was reported in such a closed environment, suffered from other types of hardships. Some of them were actually lethal. Such hardships included, unfortunately, that they were abandoned from personnel, in some cases reported, for instance, in Spain and other countries. Some of them were actually left to die out of thirst and hunger and the lack of their medication, because the personnel and the providers were terrified whenever they discovered that a few cases of COVID-19 were found within a care home for the elderly. Now, all these represent a real disadvantage situation for those people who, I remind everyone, these were already disadvantaged before being placed in a residential or institutional facility. And not only because the increased risk of dying out of COVID-19, but also because of the additional measures that made the situation worse, without really being able to obstruct the extremely high percentage of deaths, fatalities of COVID-19 in the care home system. That makes the urgent necessity to implement DI, emergency DI projects quite crystal clear. It would have been much safer for the residents of these facilities to implement acute emergency programs for deinstitutionalization. And to the cases that this actually has happened, the results were very encouraging. However, unfortunately, this is not the world trend at the time. We kept those people locked in, and we keep on counting fatalities and violations of their own human rights. How such an initiative could actually be implemented? Well, there is experience. Nowadays, there are more than 4 decades of rich experience throughout the world, both developed and developing, in such initiatives. And we know, as a global community, we know good practices, and we know erroneous past practices that led to disasters. So we can cherry pick the good ones and leave aside problematic practices, like, for instance, the DI implemented in the 70s and 80s in the United States in the mental health sector, which actually was a fast track, getting rid of people from the mental health institutions without real care, without real provision for their own rights and the safety and the continuity of their care. We know that this is bad, this is disastrous, so we can avoid it. On the other hand, we have very good experiences from a number of countries, from Europe, for instance, Italy, France, Germany, Belgium, Netherlands, the Nordic countries. We know that some of these countries in subsectors have achieved to eliminate the institutional sector. We know that, for instance, the institutions for the elderly in Norway are of a much smaller size, are like homes with a few elderly people, compared to Sweden, in which they still have a big system of big houses for the elderly. And that can really explain the differences in the death toll from the current pandemic between these two neighboring countries, or at least to some extent. We know, for instance, that in Italy, they have managed to shut down all mental health institutions, which was actually described and provided by a piece of legislation that was introduced decades ago. And this was very successful because that was supported by community-based services that could provide continuity of care and support for these people, which already were a vulnerable group of disadvantaged people. We know that they were, for instance, in Denmark or in Iceland, they were very good examples of replacing the traditional prison system with alternative sentence models and supervision of convicts. And we also know that these have worked not only in reducing the sizes of prisons, but also we know that this has had a very good effect on the criminality indicators in these countries. So we have good experiences and we have bad experiences, and we know that this is achievable. Myself, I have been working in my country for 3-4 years in the worst institution for residential care for children with disability, a horrible place which gained notorious publicity for Greece, the institution in Lehena, in which they used to place children with disability in wooden cages, 2 by 2 by 1. I found one person who was already adult was placed in a cage for 22 consecutive years without not being let outside the cage for a single moment. And I can tell you, when working there with these people who had some of them challenging behavior, especially when you just release them from restraints, that is doable. It's very achievable, and it can be done in a very safe way to bring these people from institution restriction and restrictive life into community incorporation and real life. So these initiatives can be both realistic and effective. They are effective because they do better to the well-being and the health of the residents, and they can be realistic because there is absolutely no institution which cannot be reformed towards the community incorporation of the residents. Now, why then, and after so many decades of discussions on deinstitutionalization, why then the whole world has not adopted this kind of perspective? Why on earth, when we saw the pandemic coming, countries, societies, providers did not launch immediately emergency DI projects in order to eliminate or at least minimize the big congregations of people that are currently residing in institutions. Just to respond to a question I have seen in the chat, I've mentioned France for the experience of reforming mental health institutions. I am aware of the fact that in the case of children or the case of persons with disability, situation is not that good in France as in the mental health sector. So I was discussing why we didn't adopt immediately such initiatives, and why on earth, after the experience of the spring wave of the pandemic, at least in the North Hemisphere, we did not use the experience of this increased fatality in institutional care in order to exploit the summer to dismantle the big institutional facilities. There are resistances, and I'm afraid to say that these resistances is a combination, are constituted by a combination of big interests that want to keep the institutional sector open with a vast spectrum of small interest groups that sustain the institutional care for many kinds of residents. And these resistances are quite strong in many societies. To conclude this overall presentation, I would just like to remind everyone that according to the UN fundamental conventions, like the Convention for the Rights of the Child, for the rights of the persons with disability, for people in custody or care, for immigrants and refugees, but in all such documents of humanitarian international organizations, uh, the right of liberty and the right of being able to live in a community have been underlined, and for some cases there were additionally the adoption of perspectives that placement in residential care is damaging in an irreversible manner. I'm mentioning, for instance, that in infants and toddlers, 20 years ago, the United Nations accepted the compelling evidence that the damage inflicted in the brains of children growing in institutions, especially under the age of 3, is irreversible after that age. So the UN launched the global recommendation to all states to stop immediately institutional care for infants and toddlers. However, this has not been fully realized yet. So my concluding remark is, whatever we see during the era of this pandemic is actually the rights of people who live in institutions, people who are already very marginalized and vulnerable, which pay double and triple price because of their placement in institutions, and their rights have not been fully realized before the pandemic. As societies, we had a duty for those people to let them out of the institutions, to secure them a life within the community. We haven't done so before the pandemic, and now the pandemic is just making things worse and more visible. Thank you very much.
Thank you so much, George, for the excellent presentation and for so many compelling arguments for emergency deinstitutionalization. It seems like when you hear all that, you just don't understand why it's not happening, why it hasn't happened. But I'm especially glad to hear that there are examples where something like that has happened and has happened successfully. I think that's very encouraging for all of us who are trying to litigate it or will try to litigate it. And I was wondering if perhaps, because there was also one of the questions that came in the chat, if maybe right now you could just tell us very briefly, just maybe choose one example which you think was successful and what made it successful in your opinion. Thank you.
Yeah, thank you very much. Well, there are examples, but as I said, unfortunately, they have not constituted a wide policy, a comprehensive policy. We had, for instance, some countries that released with immediate measures a lot of people convicted for minor felonies and just were placed in custodian terms while living in the community. We had, for instance, countries like Portugal, which immediately in the rise of the first wave of the pandemic granted full social security rights to all immigrants and refugees residing in the country, so that they can have access to medical services and release them from any kind of congregational facilities that they have. We also had, and this has been discussed since the summer in Spain, we had initiatives to, at least for those of the elderly that still had some families or relatives or people who could accept them to live in their houses, pilot projects in order to move from the care homes for the elderly. If you compare the fatalities in countries in the relevant sectors that actually applied such simple measures, they did much better than in countries that they still kept their overcrowded prisons without releasing anyone, or countries that kept their residential care system for the elderly intact without any initiative to move some of the residents away. In Iceland, for instance, we had this very interesting initiative to set up an hour, for instance, 1 or 2 hours in the beginning of the working hours of the shops, in which all the population agreed that they will not shop for letting the ground for the elderly that live in the community to shop. And that was very protective for the mingling of the elderly with the middle-aged and young population, in order for the elderly to be protected while staying in the community. We had a lot of examples, but insofar are quite fragmented and do not constitute a comprehensive policy, unfortunately.
Yes, but it's excellent to know that we have places to look at and to take inspiration from, even if so fragmented. I think that's very encouraging for us, and also it makes it easier to argue that implementing emergency DI in the COVID situation is actually a legal human rights obligation of the states, which is actually the topic of our second speaker today, Dr. Facundo Chávez, who I will be introducing now. Facundo is an expert in human rights working at the OHCHR in Geneva, as I've already mentioned. But before that, he has done tons of work on the national, regional, and international level in NGOs. He has also worked at the Disability Department at the Ombudsperson's Office in Buenos Aires in Argentina, and was a member of a number of organizations of people with disabilities. Facundo will, as I mentioned, be mainly talking about the legal obligations stemming from the CRPD, and will try to convince us that there is a legal obligation of the states, perhaps, to emergency deinstitutionalization, to emergency deinstitutionalize. Facundo, please take the floor. Thank you.
Thank you, Sharga, and thank you for the invitation, for inviting OHCHR to participate in this conversation. I think it's I mean, we tend to think that things are always late, but unfortunately numbers are proving us wrong, right? We continue to see, particularly now in the second wave of COVID-19 cases, that we are getting to a very worrying situation again, and we learn nothing from the first wave, right? So I think just to set the somber tone of the situation, I think we can move forward. The first thing I would like to recognize George's work on presenting the obvious situation with regard to what's happening in institutions, and also for framing institutions in the right way, right? So presenting the varied array of organizations or facilities that are operating exactly as an institutional setting that is making things even worse, right? But I think an important conversation also to start here, and why it's me speaking at this point in this conversation, it's why are we talking about persons with disabilities in this particular case, and why is also an issue that we should be paying specific attention. And this is not only an epidemic approach, that why an epidemic approach will not be sufficient to analyze this particular situation. So we're talking about persons with disabilities because persons with disabilities are overrepresented in all of these settings. Numbers in prisons, in homeless shelters, in educational facilities that operate as institutions, mainly for children, but also for adults with disabilities, facilities with intellectual disabilities, which might be the more obvious approach in terms of talking about institutions, are only one part of it, right? But we continue to see, of course, another representation of care homes, of persons with disabilities that are older persons with disabilities that are living in these facilities. And one challenge that will come, and it's actually coming already, with regard to moving into making the case for persons with disabilities, is that the data collected so far was not disaggregated in most countries by disability status. And this will present a problem for litigators when they want to address this particular issue. And so I just wanted to put it on the table, because the right to access to information will be an important point of the conversation ahead. I will not, definitely will not repeat the presentation that George did in terms of setting the scene and why are we engaging in a conversation on disability rights when it comes to persons with disabilities. The disproportionate impact has been well documented in places where information was flowing as things were happening. We continue to see that most countries are not releasing information, and they are still very protective of the information that is coming from the social services, from their health systems, and a recent research that was done by WHO that is not published yet, is actually showing that data, it's not coming consistently as it should come. The second point, and I'm again going at the issue of data, is the importance of the community data collection that is being recent. Validity is one of the organizations that were part of this larger consortium, but that were collecting data coming from persons with disabilities themselves and coming from organizations of persons with disabilities themselves to present what was happening to them, right? And I cannot stress enough the importance of listening to the experiences of people with disabilities, particularly in a context of emergency, where data systems may not be as responsive, may not be as prepared to provide a specific data representation on what is happening to persons with disabilities themselves. Before entering into the conversation that I was requested to present on today, I will make just a little bit of a nuanced approach in terms of terminology of emergency DI. So far, the Committee on the Rights of Persons with Disabilities has not given a very specific framework to this situation. It has, of course, pointed the importance of deinstitutionalization, and it was very clearly framed in the general comment on Article 19 of the community. I see Amalia Gamio in the list of participants, one of the committee members, and perhaps she can bring to the table later the work of the committee on this regard. But definitely, just to say that I would be most likely referring to emergency discharge, which I think represents better the obligation. So the first point that I would like to make from a legal perspective is that we do have a legal obligation to deinstitutionalize, right? And this is extremely clearly established in Article 19, the general comment on Article 19 of the committee has developed extensively on this. There had been conversations that the committee has engaged on issues that are related to institutions beyond the general comments, but it has been extremely consistent across all the reviews of countries on this issue, calling for plans, calling for moving in the implementation of supported structures or community-based support that could avoid what George was mentioning before of deinstitutionalizing without having a safety net, where to rely on services that at the end of the day will improve many of the outcomes that George also reflect on, including health outcomes, right? So we have to be very clear that COVID-19 is not bringing a new conversation to the table. Deinstitutionalization has been on the table for over 30 years now, with a very clear perspective on how to do it, and practices around the world in not only on aspects that may be perhaps more related to persons with disabilities, but also in other contexts, particularly with regard to prison settings, to homeless shelters, and so on, that has been proven to be the way forward. So just to frame the conversation on Article 19, there is an obligation to establish services to allow access to general service to the population of persons with disabilities, and to end institutionalization based on the argument that people should have choices on and to decide where and with whom to live, and how to move from these institutional settings to community-based settings, including home support, including personal assistance and other tools to implement this right. One of the challenging conversations that you are proposing in this set of discussions is connected to the issue of torture. And here, I think, again, we need a little bit more development from the CRPD committee. There had been some hints here and there from special rapporteurs with regard to the issue of institutionalization and torture, but mainly connected to forced institutionalization, right? So where there is a clear deprivation of liberty, there is a clear that is going against the will and preference of the person concerned. And in those cases, there had been some hints here and there. Nevertheless, the committee has not moved into that approach. And I would not definitely put words in terms of interpretation of the treaty beyond what the CRPD committee has said so far. Just to put the issue on the table, nevertheless, at this point, and particularly looking at the situation of COVID-19, we should look at the issue of assessment of severity and how those people that have been living in these institutions through the first wave had been exposed to severe psychological hardship to the point of perhaps moving to this particular realm, right? And maybe looking at issues that are connected to lower levels beyond torture of hardship that may frame the conversation in a different way. Now, starting from this point of view, I think it would be very important also to think, and I am opening the conversation in this side, to see how the obligation to prevent torture, should torture could be defined in this particular context, and also looking at issues of cruel inhuman or treatment, could these aspects, in case they can be qualified as such, nevertheless trigger an obligation on the side of the state with regard to the Convention on the prevention of torture and so on? Well, I think it would be interesting to say that there is a general obligation of prevention, that it's also part of the obligations in the Convention Against Torture, for example. So if there is a risk, a real risk of engaging in this kind of practice, I think there is a very interesting avenue to discuss. I'm sure Janos will give us a much better description of this, a strong strategic perspective of how to move forward in that sense. There are other aspects that are also connected to first right, which is the right to live independently and to live in the community, which it's related to in connection to other rights, like the right to private and family life, or the right to health in general terms, both as is this reflected in the CRPD, in the Convention on the Rights of Persons with Disabilities, as in the International Covenant on Economic and Social and Cultural Rights. Now presented the issue that there is already an obligation on deinstitutionalization, the second level of conversation should be related to the emergency component, right? And here is where I think it would be very important to look at the treaty and what are the treaty specific approaches when it comes to emergency. So the Convention on the Rights of Persons with Disabilities is one of the few treaties that has a standalone article. In this particular case, it's Article 11, that brings the mandate on states to adopt emergency measures when there is a situation of risk, right? And when George was presenting the case, it is very obvious that there is a risk for persons with disabilities, a disproportionate risk also that should be addressed. And states should be looking at this particular aspect, not in the same realm of the general obligation on ending institutionalization, but to look at it from an emergency perspective. And there is a very clear differentiation between an emergency perspective and a more common development situation in which you can plan ahead and make a larger programmatic approach to that. And in this case, we have to act now because lives are at stake. The right to life is protecting this particular aspect. And there is a lot of development when it comes to protecting the right to life from the treaty body system in the UN system, that it's calling urgent action in those cases, right? So a combination of Article 11 and Article 19 definitely gives a clear ground for emergency discharge as one of the emergency measures that should be implemented in the short term. Looking at further practice in this sense, I will not repeat again what George already presented, but there are good practices that came from countries looking at all of these different settings. Some of them were very, very well documented. Some of them actually had a very strong public debate, which is very important in this sense. Because at this moment, when we are looking at emergency measures that are restricting civil and political rights, we need to have a strong debate, particularly in parliamentarian context, to avoid making decisions that at the end of the day will end up causing more harm than providing solutions. And at the same time, to give the space for persons with disabilities in this particular case to be part of the solution, to be part of the conversation. And this had happened in some countries. We were referring to the situation in Spain, and actually Spain was one of the countries that brought this conversation to the parliament to evaluate if the measures were sufficient. And I think we have a very strong lesson learned that is coming from this, that the voices of persons with disabilities were overly silenced, I would say, compared to the voice of experts. So I think it was very important to look at this issue as an issue to improve and to improve our democratic processes, to make room to the situation of those that by many reasons had been blocked into the conversation. I would not extend too much after that. I would like to just make a couple of other points that are related to the obligations in the convention. Article 16.3 of the CRPD has a clear obligation on monitoring of facilities and programs designed to serve persons with disabilities. And many of these monitoring functions from governments were openly blocked by, as George was saying, by the restrictions that were imposed on these institutions. So you cannot leave, there are no spaces or no services to support you in the community, and while kept inside, the monitoring mechanisms had no access to these facilities. This is creating the perfect storm for what we see in reality. And this, I cannot stress again enough, that this is something that has over 30 years of discussion. All of these aspects were presented in development context, emergency state was declared, and I think that that this conversation cannot continue to happen. What we have at stake in this moment, it's a political problem. It's not a legal problem. The legal structures are there, and I think we should move into implementing measures, particularly in this emergency context, that are provided for people with disabilities themselves. So thank you, Shark. I'll come back to you.
Thank you, Facundo, so much. You raised so many important points in your presentation. Thank you. I would like to follow up on some of those. I especially think the data gathering. I think, as you said, we've been struggling with it so much. It's hard to argue for a good solution if you don't know what the current situation is. And we have seen also that people with disabilities have largely been excluded from adopting the solutions to the pandemic, to adopting the measures, to designing the measures. They have essentially been completely ignored. And that also led to the measures that were adopted, I believe, at least. I'm really glad that you raised that emergency DI is one of the obligations, one of the possible solutions to, or obligations under Article 11 and 19 of the CRPD. And I'm really glad that you raised the question of positive obligations under Article, positive obligation to prevent torture and ill treatment. And I have specific questions in relation to positive obligations to protect life of persons with disabilities in institutions during the pandemic. But I will keep that question for the second part of the webinar. And I will ask Janos Fiala to intervene right now, because I know Janos has some excellent ideas on how to use the legal framework to litigate for emergency deinstitutionalization. And I'm much looking forward to hearing his tips. I want to introduce Janos a little bit more in detail. Janos is currently he's a lecturer in international disability law at the Center for Disability Law and Policy at the University of Galway in Ireland. He also practices as a human rights attorney with extensive experience representing victims of human rights violations before international human rights bodies. I'm sure some of the disability rights cases that you know are actually cases that he litigated. You might also be interested in hearing that he has a closer link with Validity. He used to work in the former MDAC as a litigation officer, and he later became the executive director of Validity Foundation. He was also the legal director of the Disability Rights Center and the executive director of Minority Rights Group Europe. Janos, you can now take the floor.
Thank you very much, Sharka. Good morning, good evening, and good afternoon to everybody. I'm very happy to be here. I don't know if the ideas which I will present are so great as you phrased it, but I would like to follow up on the two excellent presentations of my colleagues and concentrate on how we could approach emergency DI as an issue of torture through litigation. So there is a lot of ongoing political discussion about how to transform institutions, and it has been going on for decades now. Now we have a new situation with the pandemic. So if we intervene in this discussion through litigation, taking cases on behalf of individuals who are now living in institutions and are suffering the consequences of institutionalization and the COVID pandemic, what will be the right approach? And I would like to concentrate on a few things. So first, I want to look at a bit of the history of this DI debate and just look at what does torture add to the strategy. How is it different if we identify institutionalization as an issue of torture or freedom from torture? And it's obvious that that has some advantages, but it also does have some disadvantages which are often forgotten. So it's important for us to see clearly if we are to choose a legal strategy. And after that, I would like to analyze how does the pandemic change this calculation about advantages and disadvantages? How is the situation different now compared to 2 years ago, for example? And at the end, I hope I can give some practical advice on how to take a case for those who are wishing to do that. I hope there are a few people in the audience who are interested in doing exactly just that. So, as I mentioned, as the speakers before me were talking about, transforming institution has been going on for a while, and we have an international framework on legal obligations on states that they should close institutions and build community-based alternatives instead. That framework has been in place for a while, and plans to transform institutions have been put in place for a while. Yet there is this urge on behalf of disability advocates to frame institutionalization not simply as a violation of human rights, because it violates several human rights, from the right to private life to the right to liberty, right to family life, right to independent living in the CRPD, but to frame it specifically as a right to be free from torture or inhuman degrading treatment, which together we call right to be free from ill treatment. So ill treatment is a catch-up word for torture, inhuman degrading treatment. Many reports, human rights reports, which highlighted the problems with institutions, were framing the conditions in institutions as torture or inhuman degrading treatment. And they were doing that for a particular reason. There is a moral condemnation attached to torture. So if a government is found to torturing people, there is a sense of urgency attached to it, to overcoming, to remedying the situation. So there is this hope that if we manage to identify institutionalization as torture, very fast it would be abandoned. And also connected to this to this idea is the fact that there was a lot of disillusionment about the pace of DI. So governments were coming up with all kinds of excuses how not to build community-based alternatives, how not to close institutions, and so many advocates were trying to overcome these debates with simply framing institutions as a place of torture. Torture is different from other human rights violations, which I just mentioned. In some important ways, it is absolute. Freedom from torture is absolute, and it is an immediate obligation. So if you identify something as torture, you don't debate what are the counter interests, what are the constraints, what are the resource limitations. If you identify something as torture, there is one clear answer: you have to stop it. And if it's torture, then it's simply not up for debate. You don't have to engage with the states and the medical practitioners about all the reasons for institutions still existing. They should be abolished. And we should also mention that a similar step has been done with other forms of ill treatment of persons with disabilities. So when the CRPD was debated, involuntary treatment was identified as torture. So not simply a human rights violation, but specifically as torture by some disability advocates. Restraints in institutions, again, were identified as a form of torture or inhuman degrading treatment. And the logic is very similar. If it's not torture, then it's up to an individual assessment when it is problematic or not. And then it becomes a matter of justification, a review by the domestic bodies. They have to decide individually when it is appropriate or not. And that's what many advocates wanted to avoid, because they were seeing that that debate is just not going in the right direction. And recognizing these practices is just basically legitimizing them. Similar thing happened under older mainstream instruments, and they wanted to avoid the same trap under the CRPD. So that is an important reason, that is an important advantage why we would identify DI as a form of preventing ill treatment, preventing torture. But what we should be aware that it has some disadvantages as well. So now I'm talking about it in general, not in the current situation yet. If something is torture and it is absolute, there cannot be a debate about how to implement it. And sometimes this debate is needed if the remedies are not so obvious. So we know that with DI and the transformation of services, there is a complicated policy issue about how to allocate resources, who should have priority, what should happen with the staff, and so on and so on. I'm conscious that these have been used as excuses, but nevertheless, they are also important policy considerations which have to be taken into account. And the torture framework is not necessarily the best framework for these issues to be debated, because it has simply one answer: stop what you're doing. And that's very good if what we are asking for is simply closing the institutions. But as had been said before by Professor Nikolaidis, that's not the only thing we want. We want very specific concrete measures for care to be set up in the community. And how to do that? Torture doesn't give us, a torture framework doesn't give us the clearest answer. Also, torture is an immediate obligation. So if you find a state ill-treating its subjects, persons with disabilities, the question now is then not when you should stop and how you should gradually eliminate the practice. That's not something you can do with torture. In the case of torture, you have to stop immediately. However, it has been accepted, more or less, that immediate abolishment of institutions is not realistic. At least some states are claiming it's not possible, others are saying it's not realistic. So there is a temporary situation, again, during which residents are moved out of the institution at a certain pace. Some are already out, some are still in the institution. So what happens in this intermediary period? And again, torture is not the best framework for managing some intermediary situations. It provides no protection because it has no solution for people who are in this in-between situation. Some other practical considerations. So if something is torture, the remedy is often criminal law type. So very often, specifically, the European Court of Human Rights has some very specific standards in this regard. If somebody is tortured, somebody is responsible for that and must be punished. So there is a criminal law response to torture required by the international framework. And it's not the most appropriate often in the case of institutions. So we would make care staff responsible for some of the violations. And it's really difficult to have those kind of discussions with members of the caring professional. If you tell them they're engaging in human rights violations, perhaps they could understand. But if you tell them that they are torturing people, it's very difficult to stay in discussion with them. And you need to discuss the issue with them because you need them to be part of the solution. Also, criminal law framework is not very effective in a case of systemic violations. So often, it's not the fault of individual perpetrators that the system is set up in a way it is. It's a much wider, much more systemic issue. So criminal law is often unhelpful. Yet this is the remedy what international law often requires. So these are the advantages and disadvantages in general. How does the calculation change by the pandemic? The litigation of institutions as torture has not been very successful until now. So something to qualify as torture or other forms of ill treatment, it needs to meet a required level of severity. So it must be a severe form of treatment. And even though we have many monitoring reports from human rights, from closed institutions, which show how horrible the conditions there are have been very few cases which managed to establish just that. So it's different to show in a specific situation that the person was ill-treated. If there is physical violence, sexual violence happening in an institution, or the conditions are unbearable, the physical conditions. In those situations, it's possible to establish that ill treatment is taking place, and that happened before the European Court of Rights in the case of Stanov against Bulgaria. But there were very few other cases which managed to do exactly just that. Because what you would need to do here is that not because of individual instances of ill treatment, but just by the fact that residents are closed in the institution, as a practice, it constitutes ill treatment. So ill treatment all the time, or almost all the time. And the pandemic does actually help with that, because with the connection between being locked in a closed institution, persons becoming higher risk to the COVID infection, which is a serious disease. So it's not just the fact that so many people die as a result of the COVID, but also the suffering they have to endure while infected. Shows us both the physical dangers of being in an institution and also the psychological suffering which residents have to endure in these times. So imagine if you know that, I don't know, once the institution is infected and you can't leave, somebody in the institution is infected and you can't leave, you have a very good chance of becoming severely ill and eventually dying. I think this argument could be easily understood by a court as amounting to the required level of severity. So simply this fact that you are put in such risk. There is a question in torture. So some argue, and international law has some obligations about its intent. So it's only torture if it's done with a certain intent to harm people. And some doubt or argue that institutionalization doesn't meet this criteria because it's done for good reasons. It's to help people. I think with the pandemic, this argument is difficult to maintain, because whatever the main reason of placing people in institutions, and that's also up for debate, it's also clear that the consequences of that placement are putting people in risk. And so people doing that knowingly, I think, meets the intent criteria. I have no doubts about that. So the pandemic makes it particularly easy to show that institutionalization is not simply a human rights violation, and all the other obligations are still there, but a particularly serious form, ill treatment or torture. Also, I mentioned earlier that it's difficult to manage discussions with members of the caring profession if you identify their work as torture. But that calculation is also changed by the pandemic, because they might be more accepting of the argument that, yes, keeping people in closed institutions in a situation like this amounts to torture. Okay, so governments might argue that, in this current situation, the legal framework hasn't really changed, and we already have these obligations, so we are proceeding with our DI plans, and this is nothing new. You could actually reverse the argument that the pandemic actually shows that what they have been doing until now just doesn't meet their obligations, because it just shows that they should have closed institutions a long time ago. And we know for sure that pandemics will come in the future. So we have proof currently how dangerous this is to keep people in institutions. So when the next time comes, they will not have this excuse. Now it's not just a speculation, it's not an argument. Now we have proof that it does amount to inhuman degrading treatment, to live in an institution in the times of pandemic. So practically, what could litigators do? Just to wrap up. Perhaps we should not abandon the other types of actions we can take as well. We have to recognize that it will take time. Even if we ask for emergency measures, it will take time to place people in the community, and it will not be done immediately with everybody. However, torture does create impetus on governments to speed up with implementing the DI plans and to put more resources into remedies. So on the one hand, it is very effective for specific individuals who are in a situation where they cannot leave the institution, and actually they would have an opportunity to maybe go to their families or somebody else, somebody would take them in, but they are not allowed because the DI plan hasn't progressed enough. So for those individuals, arguing that staying there constitutes torture could become very effective. They might be immediately deinstitutionalized. And for systemic remedies, the governments often argue that these measures take time and they take resources. Not everything does. So we could think of measures which could be done immediately. And that is, for example, coming up with realistic DI plans which transform institutions in a matter not of 30 years, as has been the plan in some countries, but much faster. And they could have those plans immediately, basically. So arguing that institutions in a time of pandemic constitute torture could be an actually quite effective way to commit governments to put these plans in place immediately. Thank you very much.
Thank you so much, Janos. I took about 1 million notes during your presentation. I actually think you did have 1,000 great ideas of how to use the framework really efficiently for litigation. So thank you so much. I took so many notes. I especially like so one of the common counter arguments against emergency DI, as you've mentioned, is that if it's done fast, without introducing appropriate community-based services, quality community-based services, it can lead to further endangering people in the communities, right? To putting their lives at further risk. And this idea of having backup plans or, kind of emergency DI plans that one can use if an emergency situation comes, just seems perfectly doable. And that's somewhere that's where we can take inspiration from different countries and just replicate them, I assume. So so now we have a floor for sharing these ideas or experiences or tips you may have or examples you may have heard of. I'm opening up the discussion right now. Unfortunately, we only have about 10 minutes in the webinar, but it's true that the presentations were great and they covered most of what I wanted to ask personally. So I will be asking, I will be waiting for some of the questions in the chat box. And in the meantime, I will raise the question that I wanted to raise to after Facundo's presentation, and of course it raises after Janos' presentation as well. You were both mentioning the torture framework and the obligation to prevent torture or to prevent ill treatment. But I'm wondering to which extent the right to life and the obligation to protect life of people in institutions in this situation, specifically in the pandemic, comes to play, and whether it can be argued efficiently for emergency discharge, as Facundo said. I think
yes,
I'll ask. Thank you.
Yeah, I think it's very clear that we are in the presence of an issue that is connected to the right to life, right? And in general terms, the obligations around the protection of the right to life particularly apply when there is evidence that the risk that is at stake, it's not only a health risk in general terms, but that there is an imminent impact on life. Following again George's presentation, I think there is enough evidence to support this perspective from a data point of view. And I think that the human rights argument shouldn't be particularly difficult to make on that sense. I would nevertheless say that the particular case of using the Convention on the Rights of Persons with Disabilities for this purpose may have some challenges that is related to basically the situation that it's connected to the disaggregation of data in this particular context and how information has been provided in that sense. The second part of the question, let's say that it's also connected to this, is what is going to be the immediate response now that we are already in the second wave, right? And I think a very important discussion to have at this moment in particular is the right to health, and particularly the right to prevent pandemic effect in a disproportionate manner against population in institutions through the vaccination processes, right? And here I'm a little bit concerned because so far the conversations that we have seen are very much connected to what is most obvious, right? Which is to protect first responders, so those that are working in the health system, and secondly, populations that may be considered at a higher risk of death in this particular case. But this is leaving out a couple of important points to take into consideration, particularly in the context of institutions. The first one is that many care home institutions are not considered health facilities. So personnel working in care home institutions most likely will not be prioritized to the same level as those that are working in the health system. And this is basically putting us in the same situation as we were in March, without any kind of palliative approach in this particular context, right? The second one, it's also related to what is a population in a vulnerable or higher risk situation, right? And of course, we can definitely say that all the persons will be considered here. There are a number of clear diagnoses that were already identified by WHO as some of the areas of some of the conditions that will be addressed. But it will be very difficult to have an epidemic approach to vaccination if we have to engage in detailed assessment on who should be prioritized, right? So it will be almost impossible, particularly with the volume of people that we need to vaccinate in the next year to do that. So there is a blanket assessment or a blanket categorization of persons with disabilities that may not be in those under those health conditions that will be prioritized that are equally exposed, right? So people with respiratory conditions that may not get to the point of the diagnosis that will be equal to others, those will be openly excluded, right? And you cannot enter into the detail when you started the process. So this will be a challenge, particularly in care home or institutional settings, because these populations may not be addressed on an equal basis with others, right? And further, you can of course expand this to prisons, to homeless shelters, and to other spaces where physical distancing is not possible. So I think, yeah, we need to bring back this second level of conversation if we want to be successful and avoid getting to the same levels of deaths that we had in the first wave.
Thank you very much, Facundo. We have a question from the audience. There is Amalia Gamio who asked to ask a question. Please go ahead.
Thank you very much. Can you hear me?
Yes, very well.
Okay, thank you. Congratulations of everyone. It's a very good webinar. So I would like to briefly that derived from what we saw in the pandemic, in the CRPD decided to form a working group of disinstitutionalization because violation of persons with disability persist in institutions. I completely agree with Janos that it's not realistic to close the institutions immediately, but on the light of the torture, it is necessary to start with the implementation of community supports and the transition. It is a challenge, of course, but we must be accelerated with all the actions to the institutionalization. So in CRPD, for example, we are not agree with the CRC in that small houses may be an option for children with disability. So we are now, tomorrow we start to work in the working group. So we are going to invite all the organization of society to collaborate with us, because for us it's really important to accelerate the actions to the institutionalization. So thank you very much for giving the floor, and congratulations again for all the panelists.
Thank you very much for this intervention. For those who don't know, I hope I'm not wrong to say that Amalia Gamio, a member of the UNCRPD committee. Thank you very much for the notes and for the intervention. Unfortunately, because our webinar is supposed to finish in 2 minutes, I am sorry to say that we will not have time for more questions. I'm so sorry, but I'm sure this conversation will continue, and this is not the last webinar on this topic, I think. So just let me take the last minute to wrap up. Thank you once again so much to all of our amazing panelists. I'm certainly leaving the webinar much richer in terms of knowledge and inspiration, and with many interesting impulses. And I hope the same is the case for our participants. And I would also like to thank the participants for keeping the discussion lively. You may not have seen it, but we've had a lot of questions to the panelists during the webinar as well. And last but not least, I would like to remind you that you will have one last opportunity to attend our webinar on tackling torture against people with disabilities during the pandemic next week. My colleague Felicia is moderating a webinar next Tuesday, 17 November at 2 p.m. Central European Time on essential services and psychosocial disabilities. And we'll be discussing with her panelists how to achieve redress for victims of torture during the pandemic. You will find the registration link for this webinar in the comments box. Please register. We will be happy to see you again. Thank you all again for attending and contributing to this webinar, and wish you all a very nice rest of the day.